argument in our case number CV19-0674 FC, Frederick versus Barriera. Am I pronouncing that correctly, sir?
Barriera, please.
I will try to do better. Thank you. Each side does have 20 minutes for oral argument. Mr. Barriera, if you wish to reserve a portion of that for rebuttal to get the last word, you're free to do so, but you need to keep track of the time as I will as well, okay? We don't have time cards or the clock that we would have if we were in open court. We have reviewed the case carefully. We've reviewed your briefs. We've discussed the matter in advance of today, and we'd encourage you to keep that in mind as you present oral argument to us. Proceedings are being recorded, of course, and so I would ask that you, when you speak, start by telling us the name, and if you do represent a party, the party you represent. Please also, when you are not speaking, mute your microphone if you would. Otherwise, we have kind of feedback or sound quality issues that are not helpful to us. So with that, Mr. Barriera.
Good morning, Your Honor. I would like, my name is Victor Barriera. I have a strong Portuguese accent, so please let me know if I need to repeat anything. I would like to thank you for the opportunity to present this case. I appreciate your time and this facility, without which I would still be in legal limbo, and who knows when Max will be able to see his dad again. I am here today to appeal the August 19, 2019 Superior Court ruling, and more importantly, the decision to deny my parenting time, visitation, and any contact with my son Max other than supervised. This decision has broken my heart and is certainly the most difficult thing I ever had to deal with. Not being able to see or speak to him, not knowing if he's well or sick, not being able to share his childhood. As of today, Max and I have not seen each other or spoken since August 19, 2019. In total, due to the length of the temporary orders and Max's mother, Linda, continuous violations of my parenting time, Max and I have spent less than 240 hours together, basically 10 full days, and this in roughly 2 years. I have been unable to exercise my supervised visitation rights with Max, as Linda contacted the agency and warned them that I was extremely violent and they would be putting their staff in danger. Clearly, Linda does not want for me to see Max. As I understand, we are not here today to address all the wrongs in this case, so I will proceed with the ruling of the August 2019 trial. In its ruling, the trial court indicated that mothers presented credible evidence and that mother had demonstrated sufficient facts to establish a change of circumstances such that the court should consider the petition for modification. It is my belief that the trial court decisions were relying solely on Linda's own testimony, filed pleadings, and manipulated exhibits. This without any proper evidence, no convictions, no police reports, no filed complaints, and not a single witness at trial. As such, I will be respectfully asking that your honors vacate the August 2019 trial. Here are a few examples of the accusations, the proof/evidence presented, and the outcome. Mother made some accusations on the witness stand and at trial that I provided the court with. I apologize, Your Honor. I need to restart this sentence. The trial court stated in the ruling that I disregarded Judge Ryan Toohill order and claimed Max as an exemption on my 2018 tax return. Mother made this allegation on the witness stand at trial, and Mrs. Ansel filed it in her pleading. I provided the court with my testimony and verifiable evidence, a transcript from the IRS showing that I had filed an extension for 2018 and had never filed a return. At trial, Linda's testimony and evidence was deemed credible. My testimony and the evidence from the IRS was ignored. In reality, Linda lied to the court, and Mrs. Ansel, Linda's attorney, filed allegations she knew were false. Linda's AFI and pretrial exhibits filed prior to the trial include Linda's 2018 tax return showing Max as a dependent and Linda getting full benefit for the child's credit. Both Linda and Mrs. Ansel affected the outcome of the trial and provided the court with false testimony. The same false allegations have now surfaced in the answering brief, page 18. The next one is, father routinely keeps Max from school. Linda made this false allegation in her pleadings and on the witness stand as well, yet has never provided the court with any credible evidence. I presented the court with a school's attendance record, which clearly showed that there was no issue with Max's attendance. In fact, during the year of the temporary orders, when Max spent every night with his mother, he was absent more often than when he had overnights with both parents. The trial court opted to believe mother's testimony instead of the official school documents entered as exhibits by me. Linda made the same allegations to the custody evaluator, who listed this as a factor in awarding mother's sole custody. I provided evidence to the court that the evaluator only requested the school's records the day of the trial, and these 2 weeks after she filed her report. Accusation number 3, father does not make Max do his homework when he's at his house, and Max has struggled at school since the parents' divorce. Linda made false allegations. The school never had any issues with Max coming to school unprepared or any issue with homework. I presented as evidence Max school reports. They show that Max is a good student. The court believed mother's testimony and disregarded against the evidence from school. In fact, Max performed better in school during shared visitation. Father ignored the original order precluding him from visiting Max at school during lunchtime more than once a week. These again are false accusations from mother without any proof. During the temporary orders, I always visited Max once a week, except when Linda asked me to drop off lunch for Max. Mother is actually the one who continuously violated this order. Her constant presence at school raises concerns of a real case of enmeshment. Father has refused to take Max to extracurricular activities except for soccer. I only had 3 hours with Max at the time, which did not allow us to go to events scheduled by Linda during my parenting time. The court chastised me for not taking Max to all of Linda's chosen activities, for which I was never consulted. In reality, Linda is upset that I found out that she was enrolling Max in soccer, football, basketball, swimming, and tennis, with the only purpose to meet new parents to network her business. Father has a history of manipulation, harassment, and threatening behavior. Again, these are all false allegations from Linda without providing any evidence. She repeated them to Dr. Shiley, who conducted Father's mental health evaluation. His report now suggesting, although infrequent, his temper outburst may turn into uncontrollable rage, when there is absolutely no evidence at all of any outburst or uncontrollable rage. For my U.S. residency in 1990, I was vetted by the U.S. consulate in France. U.S. Immigration Services found no criminal records, no medical and or mental issues, and subsequently granted me a green card. I have been in the U.S. since 1991, never had a DUI, never had any issues with drugs or alcohol, never been arrested for violence or any behavioral issues. From 2005 to the filing of this action in 2015, I was the stepfather to Linda's 3 young daughters. At no point during these 10 years Was there any issue or complaint about my behavior, mental health, or my parenting skills? All of these accusations were only started by Linda and Mrs. Ansel after the filing of this action. Father openly defied Judge Tullio's orders not to involve Max in the party's legal proceedings by Max sending emails to his mom. These allegations are false. I never asked Max to send any emails to Linda. He sent them on his own without my knowledge. Max is 10. He is very smart and articulate, and certainly is free and able to communicate to his mother about his needs and wants. Having a 10-year-old on temporary orders for almost an entire year, not being able to spend one single overnight or weekend with his dad, is the reason why Max reached out to his mother, and who could blame him? In regards to the testimony from Mrs. Ansel's employee, mother presented credible evidence that father intentionally tried to run over him. This did not occur. In fact, I was the one who reported to the police and the court that a vehicle had almost run into me while I was picking up Max. Police report 2018-1468479. In regards of an order of protection in favor of Linda's mom, this issue was addressed at the March 2017 trial, and Judge Kramer dismissed it. I never threatened Rita. She never filed a police report, nor testified. But unfortunately for Max, this is not the only instances of Linda lying to the court and Mrs. Ansel providing the court with allegations she knows are false. Linda's answering brief filed by Mrs. Ansel is a testimony and proof of their blatant disregard for the truth, and more importantly, the rules. I would like to address briefly the false statements provided to you in Linda's answering brief and the intentional omissions of the facts. On 5/27/16, the court appointed Julie Skakun to conduct a comprehensive custody evaluation. Mrs. Ansel omitted to tell this court that the reason for the evaluation was that I had received a week prior death threats from Linda's brother-in-law. Such threats were reported to the police, and it was successfully prosecuted by the state of Arizona. Both the court and the custody evaluator were provided evidence that both the court and the evaluator choose to hide this event from the report and the decree. On 11/8/16, father filed a petition to remove the custody evaluator. 10 days later, during a status conference, Mrs. Kakun requested that father undergo a psychological evaluation. Pending the evaluation, I raised concerns to the evaluator about Linda's irrational behavior, and as such requested that both parents submit themselves to a drug test. I immediately took one and provided the negative result to the court and the evaluator. The evaluator gave mother 30 days, and she still failed the test. I provided this result to the court and the evaluator. Neither asked for Linda to take the test again. I also provided both the court and the evaluator with both parents' board of pharmacy controlled substance records. Linda's record shows a plethora of medications for multiple physicians. In contrast, my records were empty. The evaluator concluded in a report that mother was not forthcoming with her medication history and accused me of having a substance abuse. When I filed the motion to remove the evaluator, she retaliated. She told the court that I have a mental health issue. No specific behaviors were cited. In the 6 months prior to that, she never raised any concern about my mental health. She also blamed me for delaying the trial, when the evidence showed that in the first 45 days of her appointment, she worked 45 minutes in the case. She also put the evaluation on hold for 30 days because Linda did not pay the bill. Yet I was guilty. I provided this evidence to the court. My evidence was rejected. Therefore, I became responsible for the $26,000 custody evaluation and Linda's attorney's fees. Mother provided the court and the evaluator false testimony. The evaluator retaliated. All subsequent independent evaluations in this case relied on Skakun's original bias report, even including quotes from him. My evidence has been omitted from every single ruling. The trial court found that mother had demonstrated sufficient facts to establish a change of circumstances. It is my belief that mother provided no credible evidence, no witnesses, no records, and this was based solely on mother's own testimony. The court's findings based on the best interest of the child, I just would like to bring a couple of these to your attention, Your Honor. Linda has alleged in all her pleadings that Max returns from his dad distraught and cries for days. He never cries at my house. I asked Max if he cries at his mom's. His reply was, I do sometimes. I just ask her to spend more time with you. But every time she yells and screams at me, and she tells me that she cannot do anything about it because it's all the judge's fault. The mental and physical health of all individuals involved. Dr. Shelley's report of father evaluation states, a finding of a mental disorder does not automatically or solely imply anything about the person's present parenting ability. Additionally, determination of what is in the best interest of the child requires assessment of both parents. All of my requests for Linda to have a mental health evaluation have been denied. In the best interest of the child, this court should have both parents evaluated. Linda has been in counseling on and off most of her entire life, abuses prescribed medication, and failed a drug test. Your Honor, I would like to keep the extra time for a rebuttal, please.
Very well. Thank you, sir. Ms. Ansel.
Thank you. May it please the court, my name is Yvette Ansel and I represent the appellee, Linda Frederick, in this case, who I'll refer to as mother. Parties, as you know, have one minor child. The decree was entered on April 27th, 2017, giving mother sole legal decision-making and awarding father alternating weekends and every Wednesday. The court stated it wouldn't entertain a request to modify until father engaged in counseling and demonstrated clear improvement in his communication to mother. Father did the opposite. As you can tell from the record, this case has been extensively litigated both before the decree and after. On the ruling at issue, the trial court heard evidence, including, but not limited to, that father has torpedoed a mental health exam he was ordered to conduct and made a veiled threat against that provider, that he lodged complaints against the majority of the mental health providers appointed by this court, all of which were dismissed, that he started civil litigations against mother, her family members, and her attorneys, all dismissed, that he tried to torpedo the child's counseling, that he filed a motion stating that Judge Kramer, the trial judge at that time, was engaged in fraud, that he had the young child write mother about parenting time when he was with father, when the child's counselor deemed that to be very harmful to the child, that he left the state with the child without mother's knowledge or consent, that he kept the child away from mother and even ran away with the child when he saw mother at a restaurant, that every time father spent time with the child would ask to see his counselor because he was so distraught, that father tried to run over a process server, that father frequently failed to take the child to school. And then on May 15th, 2018, the presiding judge, Janet Barton, declared that father was a vexatious litigant. The court also reviewed the court-appointed psychiatrist, Dr. Shalley's report. It was a mental health report which stated that father's actions and behaviors are representative of symptoms of a severe personality disorder. With regard to the trial court's August 2019 ruling, which is at issue in this appeal, father's argument that his contrary opinion and claim of insufficient evidence means the trial court abused its discretion is unsupported. The court issued a detailed 20-page ruling where she made specific findings under each relevant factor of 25403. She cited to portions of Dr. Shalley's report, and she cited to specific exhibits that were admitted at trial. And after reviewing that ample evidence, the trial court determined that father's parenting time must be supervised to protect the child's physical, mental, moral, or emotional health because his threats of violence, forensically informed mental health diagnosis, and flagrant disregard for the court's orders demonstrate that he will not cease the behavior deemed by several mental health professionals as harmful to this child voluntarily, and that his increasing severe conduct is placing the child at risk emotionally. The court found that unsupervised parenting time for father would endanger seriously the child's physical, mental, or moral health, or would significantly impair the child's emotional development. In addition, in terms of the brief that father did file, there was no transcript provided to this court. He failed to follow Rule 11B1 of the Rules of Appellate Procedure, obligating him to provide the court with a trial transcript. That's significant because this court must then presume that the evidence presented to the trial court supported the final factual findings and the ruling. In a case involving child custody issues, the trial court is given broad discretion to determine what will be the most beneficial for the child and what is in the best interests of that child. There cannot exist an abuse of discretion in the trial court's decision that it was in the child's best interest for father to have supervised parenting time. And it is not the appellate court's province to retry this case. Father takes issue with the court's determination of witness credibility and the weight of conflicting evidence, but this court accepts the trial court's fact findings when there exists alleged conflicting evidence. The trial court was free to give father's evidence whatever weight it thought best. In a case, day versus day, which I have in my answering brief, where the plaintiff argued that the trial court should have relied on her conflicting evidence because it was more reliable, which is very similar to what father is arguing in this case, the appellate court affirmed the trial court's division of property and found there was no abuse of discretion, noting that the transcript in that case of day versus day was filled with conflicting testimony. The main thrust of plaintiff's argument regarding the nature of ownership of the home is based on her contention that the trial court should have believed and relied on her evidence rather than the evidence presented by the defendant. The trial court's decision regarding the nature and division of property should not be overturned unless there is such a lack of evidence that the appellate court can find an abuse of discretion. The trial court did not abuse its discretion because its ruling is supported by credible evidence and is not arbitrary. And this court will not reweigh the evidence and thereby retry the case. Father's position that the trial court's findings on the factors of ARS 25403 were based solely on mother's testimony is not only incorrect, but it is not a basis to reverse or remand. First, even if the trial court's determination was based solely on mother's testimony, that testimony is sufficient to determine a fact at issue. But the trial court did not rely solely on mother's testimony in its determination. In my answering brief, I cite to various portions of the ruling wherein the trial court cited to specific trial exhibits that were provided to the court that support its findings. That the trial court didn't accept father's opposing view does not equate to an abuse of discretion. In connection with father's child support argument related to his health, father's argument that his health issues support a modification of child support does not comport with the law. There was no change of circumstances related to father's health. The issues he addressed to the court are the same exact issues presented to the court previously for a September 21st, 2017 hearing. He even presented his medical records during this trial at issue as an exhibit for the previous August 24th, 2018 hearing. And father presented no evidence related to his health or his income at the July 18, 2019 trial. To the contrary, mother presented a letter from the Social Security Administration which determined that father's condition is not severe enough to keep father from working. That was trial exhibit 9. Also, child support was modified to reflect a higher income for mother. It increased her income to $24.90 a month from her previous $10 an hour. Father also argues that the records show no mental health issue or concern, but the evidence is to the contrary. From the mental health provider who did the exam, Dr. Shalley, he found otherwise. Ample evidence exists to support the trial court's judgment. Therefore, the trial court's judgment should be affirmed. With regard to attorney's fees, there is no basis for reversal because the court made a valid determination under 25-324. The trial court determined that father's actions were unreasonable under 25-324, and he nearly bankrupted mother. Father filed numerous motions that lacked merit and has flagrantly disregarded the court's temporary and existing final orders. His conduct has unnecessarily delayed and increased the costs of litigation, which has nearly bankrupted mother. And that was a quote from the trial court's ruling. The trial court is in the best position to weigh this determination and can award fees on the basis of reasonableness, or in this case, unreasonableness alone. With regard to father's briefs, again, he failed to cite to any case law or to the record in either his opening brief or his reply brief, and that is additionally required under Appellate Rule 13A. Finally, mother is requesting fees under ARS 25-324 and Appellate Rule 21. Thank you.
Thank you, Ms. Ansel. Mr. Barriera, you have about 4.5 minutes left for rebuttal. And we're getting some echo, so if folks could mute other than the speaker.
I apologize. Your Honor, did you say about 5 minutes?
4.5, yes.
4.5. I would be very, very brief, Your Honor. We have already determined today with the tax issue that mother is not credible, that she lied in court on the witness stand, and that Mrs. Ansel filed allegations she knew was not true. In regards for the ARS 25-403, here's what I'd like to say, Your Honor. There has not been one single professional in this case that stated that Mac's relationship with his father is not a healthy one. The evidence does not support any findings regarding the meaningful contact with father. I am the only parent who complied with 25-352 at trial. I presented my proof of completion of the parent education program 2 weeks before the trial. Mother presented hers 2 months after the trial, even though Mrs. Ansel assured the judge at trial that she had completed it. The trial should have been postponed. In regards to mother's income, and this is important, for the March 17 trial, Mrs. Ansel filed an AFI for mother that was over 6 months old. Forgot to mention that mother had $300,000 in a brokerage account and did not disclose mother's 2016 income at all. It was at the time full-time, showed that she was making $10. I presented evidence to the court based on the bank statements that mother hourly rate was over $100 an hour. So basically, Your Honor, since 2017 to 2019, mother's hourly rate was $10 an hour. The 2018 tax return for mother, Schedule C, shows that mother's sales were $400,000. How can somebody have $400,000 in sales and have an hourly income of $10? This was based for the child support. Now, the change of circumstances, yes, I had an accident, I was injured, I provided the court with my information. At the same time, I was trying to have my child support changed. Mother was selling $400,000 a year and trying to get me to not have my day in court. Mother says that she somehow now, I tried to bankrupt her. She provided no evidence, absolutely at all. The 2018 tax return, Schedule C, shows that she sold $400,000. She lives a lifestyle that does not reflect someone that is in near bankruptcy. She has paid Mrs. Ansel over the years $100,000 in attorney's fees. I don't know what else to say, Your Honor. I would like to thank you for your time. I would like to thank you for your time, Your Honor. I would like to respectfully request that in the best interest of this child, the court reverse the Superior Court judgment, because this judgment is not in the best interest of the child. And it has been now proven without any doubt that both mother and Mrs. Ansel have provided the court with allegations they know are false. Thank you for your time.
Thank you. We appreciate your oral argument. We appreciate your briefing. We will take the matter under advisement. We will issue a written ruling in due course. At this time, we'll release the parties and the judges will stay on to confer. So thank you very much.
Thank you.
Your Honor.